Hello, I'm Angeline Fraser, State Legislative Affairs Director with the National Association of Criminal Defense Lawyers, or NACDL. Since mid-2007, NACDL has conducted an in-depth study of a phenomenon that is radically altering the criminal justice system, the proliferation of problem-solving courts. NACDL's Task Force on Problem-Solving Courts was charged with conducting a thorough analysis of these courts, specifically focusing upon the ethical implications for the defense bar and the constitutional implications for society at large. To fully understand the ramifications of problem-solving courts, the task force conducted 7 hearings throughout the country in San Francisco, Miami, Tucson, New York, Milwaukee, Austin, and the District of Columbia. The culmination of this project is a comprehensive report and recommendations that for the first time provide the perspective of the nation's criminal defense bar. The task force received testimony from more than 130 witnesses representing every aspect of the problem-solving court infrastructure. They also conducted first-hand observation of various courts and collectively devoted approximately 2,000 hours in prep and meeting time. The following video excerpts represent a sample of the more than 60 hours of witness testimony at the national hearings. The complete transcript of the testimony of every witness, the mission of the task force, related materials including questionnaire responses from more than 450 attorneys around the country, and the final report may be found at NACDL's website at www.nacdl.org. Thank you. We appreciate your attention.
My problem with the problem-solving courts are that I don't think that's a function of the criminal justice system. The problems that those courts are facing are social problems. I don't think the criminal justice system is designed, nor do I think it can, address social problems or correct social problems. I believe that all the criminal justice system was designed to do and can do is to address symptoms. And it's up to the larger society and legislatures and other organizations to address these issues before they become criminal problems. What we're doing by setting up these courts is backloading the issue, backloading the costs and backloading the treatment, when in fact we ought to be front-loading that. We ought to have these facilities available prior to any person becoming involved in the criminal justice system, and that's where the treatment should begin. I fear that by setting up problem-solving courts like this, we are enabling our legislators and our leaders to fail to properly fund treatment programs, education, and health services, because we have given them an excuse not to do that. And frankly, the reason we have many of these problems is because they haven't provided funding, especially in Arizona.
Drug court, for me, initially was something to be skeptical about, was something to be concerned about. Was this just another program? What's going to happen to the dispositions on our cases? You know, this was a problem. It was not something which I had received very well. But as time went on, I gained greater and greater confidence in it as a program.
I'm about 2.5 years into public defender practice, so most of my experience is in the misdemeanor Manhattan Treatment Court. I've had a few clients take DTAP pleas, but none have finished their cases yet. In misdemeanor Manhattan Treatment Court, in contrast to the Bronx, the jail alternative is 6 months if you fail. This is way out of line with most of the plea of the charge recommendations that people would get on, say, a simple crack possession or petit larceny, which is typically for simple possession between 10 and 20 days. Excuse me. Petit larceny may run up to 45, 60, sometimes 90 days, depending on the rap sheet.
It relates to communities of color. Problem-solving courts purport to give voice to communities of color in the criminal justice system, but in this regard, they have failed miserably. I know that everyone in this room is aware of the fact that in virtually every urban area in the United States, it is difficult to get a more representative jury representing all the cross sections of the community and diversity that our cities offer. In San Francisco, Chicago, and here in Manhattan, the problem is that the central courthouse is situated far away from often the areas where crimes occur.
The Broward County model is a pretrial, but the pretrial mental health strategy. We do not consider ourselves a program. We do not have programmatic standards like a drug court model. It's purely voluntary. I will not have, nor do I in the design features require any kind of plea to access this court. It is primarily diversionary in nature. It is meant to find the sickest of the sick in the jail system and move them out to be independently evaluated by what we consider to be the more appropriate system of care, that being the civil system.
Is yours a diversion court so that if they complete the drug court, their charges are dismissed or they're placed in the drug court as a condition of probation?
It's a diversion court. Most of our cases are cases where they have not been indicted and they come to our court, and if they do complete it successfully, they're eligible to get their cases expunged or their records expunged or erased in most cases.
And I'll just say as an afterthought, I've found that ethical issues for lawyers in these alternative courts are, to my way of thinking, a whole new ballgame, a whole new way of looking at the practice of law. And I sometimes feel that my clients are kind of square pegs that I'm trying to fit into the round holes of traditional lawyer ethics. And I could tell you a lot of situations that I find it difficult, and I worry over it a lot. If I'm doing the right thing by following the ethical regulations or doing what I think is right for the clients.
I'm absolutely in favor of defense lawyering, and I might be in favor of certain problem-solving courts under certain circumstances. I am not in favor of the federal government throwing millions and millions and millions of dollars at an experiment that we don't know if it works, and nobody is monitoring in really any effective way what's taking place on a day-to-day basis in terms of protecting defendants' rights.
I would say that the most difficult and challenging role for a defense attorney in the NA drug court is being a team member when you're talking about the attorney-client privilege. You have to draw the line there. You have to draw the line there.
With mental health courts, everybody from the bailiff to the court reporter to the judge to the clerk is much more sensitive, much more tuned in. It becomes an environment that is a safe environment rather than an environment that hurts them.
It's very effective. And the proof of that is that the individuals that complete drug court have a very small, minute recidivist rate. I think we at one time calculated to be, what, 4%, Judge?
Within Dade County.
Within Dade County, of the people that completed the program, that went all the way through and did everything they were supposed to, and they were actually rehabilitated, very low recidivist
rate, how far out did you?
1 year, 4%, 2 years, 6% in Dade County.
Okay.
And what's the success rate for completing the program?
Judge?
About 65%.
I will tell you, we get pressure from our staff about the frustration they feel in these courts of we hire them to be scorched earth litigators, and these are frustrating courts for them to work with. And likewise, we hear from the judges who question how suited we are to this work.
If this task force can come up with a guideline for attorneys to counsel people, then you may have achieved something which would have a greater effect than dealing with the actual process of these courts.